Between 2008 and 2011, a massive corporate network quietly absorbed over 24,000 crore rupees from nearly 3 crore individual investors, completely avoiding the radar of India's capital market regulators. The company collecting these funds was the Sahara Group. At the time, they were a ubiquitous presence in the Indian national consciousness, sponsoring the national cricket team and operating a vast empire that spanned real estate, media, and aviation. At the very top sat Sabrana Roy Sahara. He projected absolute authority and financial invulnerability, operating an organization that commanded fierce loyalty and operated with deep internal secrecy. To structure this specific capital-raising effort, the group utilized 2 unlisted public companies, Sahara India Real Estate Corporation Limited and Sahara Housing Investment Corporation Limited. The scale of Sahara's public-facing brand provided an ideal shield. Millions of citizens recognized the name and trusted the logo, enabling a multi-billion-dollar financial operation designed specifically to remain invisible to regulatory oversight. The mechanism driving this collection was a financial instrument called an OFCD, an optionally fully convertible debenture. In practice, this is a debt security that allows the investor to either redeem their money with interest or convert it into company shares at a later date. To solicit these funds, Sahara relied on a specific legal defense. They argued that as unlisted companies, they were executing a private placement. They claimed the offers were restricted to a closed circle of friends, associates, employees, and individuals already affiliated with the Sahara Parivar. Under this interpretation, Sahara bypassed the Securities and Exchange Board of India entirely. Instead, they filed their red herring prospectuses with local offices of the Registrar of Companies in Kanpur and Maharashtra. Across the top of their information memorandums, they printed a clear directive: private and confidential, not for circulation. This self-classification meant they avoided listing on any recognized stock exchange. It exempted them from issuing public financial disclosures, appointing debenture trustees, or creating reserve funds to protect the people handing over their savings. It was a total blackout of the public market protocols. By stamping the word private on their paperwork, Sahara operated under the assumption that they had legally walled off a 24,000 crore rupee operation from the nation's primary market watchdog. That assumption held until 2010, when the operation caught the attention of the Securities and Exchange Board of India, headquartered in Mumbai. The discovery was incidental. SEBI was processing a routine initial public offer for an entirely different Sahara entity, Sahara Prime City. During that review, external complaints from a professional investors group arrived, pointing out massive irregularities in the OFCDs issued by the real estate and housing companies. SEBI initiated an investigation and issued summons, requesting basic data: the number of application forms, the subscription amounts, and a list of the allotees. Sahara immediately stalled. They submitted detailed letters objecting to the inquiry, but repeatedly failed to produce the actual subscriber records. When pressed, Sahara mounted a jurisdictional defense. They argued that because OFCDs were hybrid securities, blending debt and equity, they fell completely outside the legal definition of securities governed by the SEBI Act. They backed this up with an argument for corporate autonomy. As unlisted companies, they insisted their only regulatory master was the Ministry of Corporate Affairs, explicitly rejecting any authority from the capital markets regulator. The result was a high-stakes standoff.
Sahara utilized precise, hyper-technical readings of corporate law to assert that SEBI had no legal right to even ask questions about the billions of rupees flowing into their accounts. SEBI countered this defense using a strict mathematical provision written into Section 67, subsection 3 of the Companies Act, widely known as the Rule of 50. The law dictates a hard boundary for private placements. A company can offer shares or debentures privately to 49 people, but the moment an offer is made to the 50th percent, the law automatically reclassifies the entire operation as a public issue. Once an offering crosses into public territory, Section 73 of the Companies Act activates. The company is legally obligated to apply for listing on a recognized stock exchange, submitting itself to strict investor protection guidelines. Sahara's claim of a private domestic arrangement fractured under the weight of its own logistics. SEBI's investigation revealed that the 2 companies were using a network of 10 lakh agents operating out of more than 2,900 branch offices across the country. SEBI's random address checks identified ordinary citizens solicited by local agents. Many of these investors had no prior connection to the Sahara Group and were unable to describe the characteristics of the optionally fully convertible debentures they had purchased. A private placement requires a closed, identifiable circle. Deploying 1 million agents to collect funds from a population larger than the country of Australia completely dismantled Sahara's legal narrative. The battle over jurisdiction and definitions ultimately escalated to the Supreme Court of India. In court, Sahara presented a final argument centered on their internal corporate will. They argued that because their paperwork explicitly stated they never intended to list their securities on a stock exchange, the mandatory listing provisions of Section 73 simply could not apply to them. The Supreme Court rejected this logic entirely. The justices ruled that corporate behavior is judged by the acts committed, not the intentions declared. Because Sahara actively invited subscriptions from millions of people, they triggered the public issue threshold. Refusing to list the securities was not a defense, it was a deliberate violation of the law. The court also resolved the jurisdictional turf war in SEBI's favor. They confirmed that the definition of securities includes hybrids like OFCDs. More importantly, they ruled that SEBI has the mandate to administer the law for any public company, listed or unlisted, the moment it attempts to raise capital from the general public. A company cannot circumvent mandatory listing rules and investor protection protocols by quietly slipping a private label onto a deeply public solicitation. The court's final order was uncompromising. They directed the 2 Sahara companies to refund the entire amount collected, over 24,000 crore rupees, directly to the genuine subscribers, along with an additional 15% interest. To ensure compliance, the court stripped Sahara of its operational autonomy regarding the payout. SEBI was tasked with verifying the identity of every single subscriber, with the entire refund process strictly overseen by retired Supreme Court Justice B.N. Agarwal. The ruling effectively closed the private placement loophole for unlisted companies. By affirming that SEBI's oversight is triggered by the act of soliciting more than 49 people, the court removed the ability for corporations to self-classify their way out of public market accountability. The case demonstrated that the scale of a corporate group does not provide immunity from regulatory scrutiny. Even with thousands of branches and complex financial instruments, the requirement for transparency toward the investing public remains the governing standard.